What's going on in town right now is a developer, Invenergy, has come in and is attempting through the Article 10 process in New York to set up a wind farm of 600-foot turbines. The town is acquiescing that and allowing it to happen by changing their law to match that, and tonight they're looking at reducing the setbacks from homes, property lines, and streets in order to accommodate more 600-foot turbines, which Cattaraugus County has already said no to, and the people have unanimously said no at every public hearing, at the poll they took, and at all of the Article 10 hearings. So I don't see why this is continuing to go forward. There's absolutely no reason. A law passed under conflict of interest, which is exactly what this is, with 3 board members with a conflict, can be thrown out and it can be sued. Come January, it's most likely getting thrown out if it's put in. And they will be hearing from all of us tonight that this is not what's going to happen. Hopefully I can work for the people as opposed to what's going on in here now. I think that's the reason why you see the unanimous vote that went through in the primary. What I'd like to do is find contractors, developers, businesses that are willing to come into the area. I'd entertain developers all day long. However, not a raw deal like this. This is absolutely ridiculous.
Well, we expect that our town board will be trying to pass a wind law since they were all handily defeated in the primary elections, and they know their time is limited, so their promise to not pass any new wind law in 2019 is quickly going by the wayside. We believe if they do pass a wind law tonight, it will be in violation of the law, and we will sue them.
I just want to represent that the town of Franklinville is against the windmills. We want them to respect the residents of the area who have voted and said, this is not good for us. And the town of Franklinville has also said, folks, it's not a good idea for us. It's going to spoil all of the beauty and nature that we have here today. So we have representatives here today that I hope can get in, since it's a limited of 50 people to get in to speak. But I hope that they pay attention, because they said no new wind law, and that's not what's going on here tonight. Backhand politics, I guess it is, or whatever the term is, so that they can get what they want into the system without fully observing what should have been done. When they said no new wind law, the rest of us thought that was true, but they haven't stuck to their word since they came in with a wind law that they want to do tonight.
You think what's going to happen here tonight?
What's going to happen here tonight? Probably something that I wish wasn't going to happen, and I thought we were told that at one of the previous board meetings that there would be no vote on the wind business, but I kind of think that tonight is going to be the night that there is going to be the vote, and I have no idea how it's going to come down. So I honestly think they probably have the votes.
Do you think it can be overturned? Sorry. Once they do this?
Afterwards, I think certainly the only thing you can do is work on it. You know, I'm the county legislator, so I'm kind of neutral, even though I do live in Farmersville. And so I'm not neutral, but I don't think all the questions have been answered yet, and so on. And I think this board needs to do what the people have voted them in to do. And that's what I've done for the past, I'll be termed out for the county for the past 11 and 8 months now. That's what I've done, is done what I feel the people in the Cattaraugus County wanted. So as far as Cattaraugus County, we passed the resolution that the IDA does not give them the pilot program. That was very important. This board has something to be gained by passing this. Yes, I think I only know of one that probably doesn't have a conflict, and I had hoped that there was one other one that would vote no, and I'm still hoping tonight, but I kind of think that that's probably not going to happen.
Thank you, sir. How are you?
Everybody ready? Everybody sit up and start the meeting with the pledge. I don't know where the flag went.
Behind you.
Thank you. I pledge allegiance.
indivisible, with liberty and justice for all.
We're to our max tonight for people. I just want to point out the exits. The door you come in, the side door, and there's another door in the back. The restrooms, the ladies is off to the right, and the gents are off to the left.
We just handed you some materials that the residents would like you all to consider before voting on any wind law, including
Excuse me, look it, there's not going to be any comment. You're going to sit, you're going to listen, we're going to conduct our meeting.
So says you.
Okay, I want to introduce myself. If you don't know me, Rob Karcher, supervisor. If we go around the table quick, just, we had a request so everybody knows everybody from the legislators.
Richard Zink, Town Councilman.
George Duncan?
Pam Tilton?
Dave DiMatteo, Town Attorney.
Bridget Holmes, Town Clerk.
Okay, at this time, I'd like to turn the meeting over to Dave.
Again, we're attempting to work through this. We probably will not be taking any comments from the floor. You're more than welcome to watch us work. And again, if you're gonna make comments and you're gonna disrupt this meeting, we won't be here.
We'll just shut it down and,
No, we're gonna stay, they're gonna leave. It's as simple as that. Title of this law, okay, that, again, we had before us the last time we were here, is the Wind Energy Facility Law of the Town of Farmersville. Again, there's a little bit of salutation at the beginning about the fact that that there's been a history of some wind laws in the town of Farmersville, the 2007, the 2008, and the 2009. Again, I went through the title. The purpose of this law is adopted to promote effective and efficient use of the town's wind energy resource. Again, the town board, following the thorough review of the town planning board. So there we go, we got a mistake already. We don't have a planning board, right?
right.
So that's why we're here. Finds the current law of 2009 requires, approved by the town board, finds that the current law of 2009 requires certain changes to reflect the changes in wind energy conversion systems technology. The town of Farmersville is supportive of responsible green energy development and promote health, safety, welfare, and safety of the citizenry in the town of Farmersville and encourage economic development and opportunities. And local law number 1 of 2009 must be updated to reflect the changing circumstances and technology developments that have taken place since then. Board of Farmers enacts this law under authority. Again, the authority is set forth in New York State law under Article 9, New York State local governments law, Section 10, municipal home rule law, town law, and New York town law, Section 64 and 130. The town board of the town of Farmersville finds and declares, and again, it talks about why we're doing this. That there's a wind energy is abundant, renewable, and non-polluting. The generation of electricity from properly sited wind turbines, including small systems, can be cost effective. In many cases, the existing power distribution systems may be used to transmit the electricity from wind generating stations to utilities or other users, or energy consumption at the location that can be reduced. Regulation and siting of the installation of wind turbines is necessary for the purpose of protecting the health, safety, and welfare of neighboring property owners. Wind energy facilities represent significant potential aesthetic impacts because of their large size, lighting, shadow flicker effects. Wind energy represents significant potential aesthetic impacts because of their large size, lighting, a shadow flicker effects, if not properly sited. If not properly regulated, the installation of wind energy facilities can create drainage problems through erosion and lack of sediment control for the facility and access roads, sites, harm farmlands, and thorough and proper construction methods. Through improper construction methods, wind energy facilities may present a risk to bird and bat populations if not properly sited. If not properly sited, wind energy facilities may present a risk to property values of adjoining property owners. Wind energy facilities may be a significant source of noise, which if unregulated can be negatively impact the adjoining properties. Without proper planning, construction of wind energy facilities can create traffic problems and damage local roads. If improperly sited, wind energy facilities can interfere with various types of communication. Permits required. Transfer and modifications. No wind energy facility shall be constructed, reconstructed, modified, or operated in the town of Farmersville except in compliance with this local law. No WEC shall be constructed, reconstructed, modified, or operated in the town of Farmersville except with a wind energy facility permit approved pursuant to this law. Again, if I'm going too fast, or if you want to talk about something, stop. No wind measurement tower shall be constructed, reconstructed, modified, operated in the town of Farmersville except pursuant to the wind energy facility permit issued pursuant to this law. No small wind energy conversion system shall be constructed, reconstructed, modified, or operated in the town of Farmersville except pursuant to wind energy permit issued pursuant to this law. This local law shall apply to all areas of the town of Farmersville. Exemptions. No permit or other approval shall be required under this chapter for WECs utilized solely for agricultural operations in a state or county agricultural district, as long as the facility is set back at least 1.5 times its height from the property line and does not exceed 120 feet in height. Towers over 120 feet in height utilized solely for agricultural operations in a state or county agricultural district shall apply for a wind energy permit in accordance with Article 2 of this local law, but shall not require a height variance. Prior to the construction of WECs under this exemption, the property owner or designated agent shall submit a sketch plan or a building permit application to the town to demonstrate compliance with the setback requirements. Transfer. No transfer of any wind energy facility or wind energy permit, nor sale of the entity owning such facility, including the sale of more than 30% of the stock of such entity, not counting sales of shares on a public exchange, will occur without prior approval of the town, which approval shall be granted upon written acceptance of the transfer of the obligations of the transfer under this section and the transferee demonstration in its sole discretion of the town board that it can meet the technical and financial obligations of the transferor. No transfer shall eliminate the liability of the transferor nor any other party under the section unless the entire interest of the transferor in all facilities of the town is transferred and there will be no outstanding obligations or violations. Notwithstanding the requirements of this section, replacement in kind or modification of wind energy facility may occur without town board approval when there is no increase in total height, no change in the location of the WEC, no additional lighting or change in facility, no increase in noise production is produced by the WEC, and the WEC is currently not in violation of any permit or provision of this local law. Definitions. As used in this local law, the following terms shall have the meanings indicated. Agricultural or farm operations means land on a farm and on farm buildings, equipment, manure, processing, handling, practices such to contribute to the production, preparation, and marketing of crops, livestock products as a commercial enterprise, including commercial horse boarding operations as defined in subdivision 13 of New York Ag and Markets 301. Timber processing as defined in subdivision 14 of New York Ag and Markets 301. Such farm operation may consist of one or more parcels of land owned or rented, which parcels may be contiguous or non-contiguous. EAF is an environmental assessment form under seeker as defined by 617 of the New York State Code Rules and Regulations. A residence means any dwelling suitable for habitation existing in the town of Farmersville on the date the application is received. A residence may be part of a multiple dwelling, multi-purpose building, but shall not include buildings such as hunting camps, hotels, hospitals, motels, dormitories, sanitariums, nursing homes, schools, or other buildings used for educational purposes or correctional institutions. Seeker, again, New York State Environmental Quality Review Act. Sound pressure level means level which equaled or exceeded a stated percentage of time. L1050 dBA indicates that in any hour of the day, 50 dBA can be equaled or exceeded only 10% of the time or for 6 minutes. The measurement of the sound pressure level can be done according to the international standards of acoustic noise measurement techniques for wind generators, IEC 61400-11, or other accepted procedures. Site, parcel of land where a wind energy facility is to be placed. The site can be publicly or privately owned by an individual or a group of individuals controlling a single or adjacent properties. Where multiple lots are in joint ownership, the combined lots shall be considered as one for purposes of applying the setback requirements. Any property which has wind energy facility or has entered an agreement for such facility or setback agreement shall be considered off-site. Small wind energy conversion system, a wind energy conversion system consisting of a wind turbine, a tower, and associated control or conversion electronics, which are rated capacity of not more than 100 kilowatts, which is intended primarily to reduce the consumption of utility power at the location. Total height of the tower at its furthest vertical extension of the WEX. George?
Can we go back to that sound? How do they regulate, or how do they know? Is there a meter on each?
It's my understanding there is, and again, I indicated to you Monday night, we're going to have our engineer here.
Okay.
And instead of me butchering it with
We'll
legal
wait and see what it
jargon,
is.
yeah,
Okay.
somebody who does this every day, and that's what they're
Okay.
if that's okay.
Yeah, oh, so, yeah.
Okay.
It seems to be one of the big,
Okay, let's highlight that so we know to come back to it Monday night. Wind energy conversion system, a machine that converts kinetic energy in the wind into usable form, commonly known as wind turbine or windmill. Wind energy facility, a development project consisting of integrated system of wind energy conversion systems, small wind energy conversion systems, including wind measurement towers and associated wind-related infrastructure. Wind energy-related infrastructure, the components of a wind energy facility excluding WEX and wind measurement towers that are necessary or convenient for the construction or operation of the wind energy facility, including electronic collection lines, substations, interconnection lines, switch yards, access roads, communication facilities, operation and maintenance building and facilities, laydown yards, and concrete and batch plants. Wind measurement tower, a tower used for the measurement of meteorological data such as temperature, wind speed, and wind direction. Wind energy permit, a permit granted pursuant to this local law granting a holder the right to construct, maintain, and operate a wind energy facility. Applicability. The requirements of this local law shall apply. So just stopping there, we defined the terms. Hopefully as we go through this, anytime we come to a term that doesn't have a common meaning, it's defined up there, okay? The requirement of this local law shall apply to all wind energy facilities proposed, operated, modified, or constructed after the effective date of this local law. Wind energy facilities for which a required permit has been properly issued and upon which construction has been commenced prior to the effective date of this local law shall not be required to meet the requirements of this local law, provided, however, properly issued upon which construction has commenced prior to the effect of this local law shall not be required to meet the requirements of this local, provided, however, that, number one, any such pre-existing wind energy facility which does not provide energy for a continuous period of 12 months shall meet the requirements of this local law prior to recommencing energy production. No modification or alteration of an existing wind energy facility shall be allowed without full compliance with this local law. Any wind measurement tower existing on the effective date of this local law shall be removed no later than 24 months after the effective date unless the wind energy permit for said wind energy facility is renewed and obtained through written application and payment of the appropriate fee. Applications for wind energy permits for wind energy facilities. An application for a wind energy permit for a wind energy facility shall include the following presented in the following order: name, address, and phone number of the applicant. If the applicant is represented by an agent, the applicant shall include the name and address and telephone number of the agent, as well as the original signature on the applicant and authorizing representation. The name, address, phone number of the owners of the property in which the wind energy is to be located. If the property owner is not the applicant, the application shall include a letter or written permission signed by the property owner confirming that the property owner is familiar with the proposed application and is authorizing the submission of the application. Address and other property identifications such of each proposed WEX location, including the tax map, section, block, and lot number. A description of the project, including the number of maximum rated capacity of each WEC. A plot plan prepared by a licensed surveyor or engineer drawn to sufficient detail to clearly describe: 1. Property lines and physical dimensions of the site. 2. Location, approximate dimension, types of major existing structures and uses on the site, public roads and adjoining properties within the setback distances specified in 13E of the boundaries of such proposed WEC site, location and elevation of each proposed WEC, location of all the above ground utility lines on the site or within 1 radius of the height of the WECs, transformers, power lines, interconnection point with transmission lines and other and ancillary facilities or structures. Location and size of structures above 35 feet within the setback distance is set forth in 13A of the proposed WECs. For purpose of this requirement, electrical transmission and distribution lines, antennas, slender or open lattice towers are to be considered structures. To demonstrate compliance with the setback requirements of this local, circles will be drawn in the proposed towers to equal to each setback distance specified by 13A. Location of the nearest residential structures located off-site and the distance from the proposed WECs. All proposed facilities, including access roads, electrical lines, and substation storage maintenance units and fencing. Vertical drawings of the WEC showing the total height of the turbine dimensions, the tower, the turbine colors, ladders, distances between the ground and the lowest point of any blade, location on the climbing pegs, and access doors. One drawing may be submitted for each WEC of the same type. A total height, for some reason I have the letter L there. I'll have to check that. Okay. Landscaping plan depicted existing vegetation and describe any areas to be cleared and specimens proposed to be added. Identify species, the size of the specimen at installation and their location. Lighting plan showing any FAA required lighting and other proposed lighting. The applicant should include a copy of the determination from the FAA to establish the required markings and/or lights for the structure. But if such determination is not available at the time of the application, no building for any lighted facility may be issued until such determination is submitted. A list of property owners with their mailing addresses within 500 feet of the boundaries of the proposed site. The applicant may delay submitting this list until the town board calls for a public hearing on the application. Decommissioning plan. The applicant shall submit a decommissioning plan which shall include the anticipated life of the WECs, the estimated decommissioning costs in current dollars, how said estimate was determined, the method of ensuring the funds will be available for decommissioning and restoration, the methods such as an annual re-estimate by a licensed engineer that decommissioning costs will be kept current, the manner in which the WECs will be decommissioned and the site restored, which shall include the removal of structures and debris to the depth of 3 feet, restoration of the soil, restoration of the vegetation consistent with compatible surrounding vegetation, less any fencing or residential minor improvements requested by the landowner. And it's not residential, it's residual. Sorry about that, residual. Complaint resolution. The application will include a complaint resolution process to address complaints from nearby residents. The process may use an independent mediator and arbitrator and shall include a time limit for acting on a complaint. The applicant shall make every reasonable effort to resolve the complaint. The application shall include relating to the construction installation of the wind energy conversion facility as follows: construction schedule describing expected commencement and completion dates, a description of the anticipated routes to be used by construction and delivery vehicles, and gross rates and heights of those loaded vehicles. Completed Part 1 of the full environmental assessment form. Number 14, applications for wind energy permits for wind measurement towers subject to this local law may be jointly submitted with the wind energy facility application. For each proposed WEX, include make, model, picture, manufacturer specifications, including noise decibels data, include manufacturer's material safety data sheet, documentation for the type and quantity of all materials used in the operation of all equipment, including but not limited to all lubricants and coolants in it. Give me one?
Yes.
Thank you.
Anybody else?
Thank you.
You want anything in it?
No. Give me some honey. He would have brought it if I knew.
I would have.
Number 16, if the applicant agrees in writing in the application that the proposed WEX may have significant adverse impact on the environment, the town board may issue a positive deck of environmental significance. If a positive deck for environmental significance is determined by the seeker lead agency following the information included in the draft environmental impact statement for the wind energy facility, otherwise the following studies shall be submitted in the application: shadow flicker, visual impact, fire protection, noise analysis, and again, I know you were interested in noise, so I'll go through that real quick. A noise analysis by competent acoustical consultant documenting the noise levels associated with the proposed WEX. The study shall document noise levels at property lines in the nearest residence not on site. If the access to the nearest residence is not available, the town board may modify this requirement. The noise analysis shall include low-frequency noises. Property value analysis prepared by a licensed appraiser in accordance with the industry standards regarding potential impact of values of property in neighboring WEX sites.
Hey, let's go back to D for a second.
Yes, sir.
So,
Substations, interconnection lines, switch yards, access roads, communication facilities, operation and maintenance building and facilities, laydown yards, and concrete and batch plants. Wind measurement tower, a tower used for the measurement of meteorological data such as temperature, wind speed, and wind direction. Wind energy permit, a permit granted pursuant to this local law granting a holder the right to construct, maintain, and operate a wind energy facility. Applicability. The requirements of this local law shall apply. So just stopping there, we defined the terms. Hopefully as we go through this, anytime we come to a term that doesn't have a common meaning, it's defined up there, okay? The requirement of this local law shall apply to all wind energy facilities proposed, operated, modified, or constructed after the effective date of this local law. Wind energy facilities for which a required permit has been properly issued and upon which construction has been commenced prior to the effective date of this local law shall not be required to meet the requirements of this local law, provided, however, properly issued upon which construction has commenced prior to the effect of this local law shall not be required to meet the requirements of this local, provided, however, that, number one, any such pre-existing wind energy facility which does not provide energy for a continuous period of 12 months shall meet the requirements of this local law prior to recommencing energy production. No modification or alteration of an existing wind energy facility shall be allowed without full compliance with this local law. Any wind measurement tower existing on the effective date of this local law shall be removed no later than 24 months after the effective date unless the wind energy permit for said wind energy facility is renewed and obtained through written application and payment of the appropriate fee. Applications for wind energy permits for wind energy facilities. An application for a wind energy permit for a wind energy facility shall include the following presented in the following order: name, address, and phone number of the applicant. If the applicant is represented by an agent, the applicant shall include the name and address and telephone number of the agent, as well as the original signature on the applicant and authorizing representation. The name, address, phone number of the owners of the property in which the wind energy is to be located. If the property owner is not the applicant, the application shall include a letter or written permission signed by the property owner confirming that the property owner is familiar with the proposed application and is authorizing the submission of the application. Address and other property identifications such of each proposed WEX location, including the tax map, section, block, and lot number. A description of the project, including the number of maximum rated capacity of each WEC. A plot plan prepared by a licensed surveyor or engineer drawn to sufficient detail to clearly describe: 1. Property lines and physical dimensions of the site. 2. Location, approximate dimension, types of major existing structures and uses on the site, public roads and adjoining properties within the setback distances specified in 13E of the boundaries of such proposed WEC site, location and elevation at each proposed WEC, location of all the above ground utility lines on the site or within 1 radius of the height of the WECs, transformers, power lines, interconnection point with transmission lines and other ancillary facilities or structures. Location and size of structures above 35 feet within the setback distance is set forth in 13A of the proposed WECs. For purposes of this requirement, electrical transmission and distribution lines, antennas, slender or open lattice towers are to be considered structures. To demonstrate compliance with the setback requirements of this local law, circles will be drawn in the proposed towers to equal to each setback distance specified by 13A. Location of the nearest residential structures located off-site and the distance from the proposed WECs. All proposed facilities, including access roads, electrical lines, and substation storage maintenance units and fencing. Vertical drawings of the WEC showing the total height of the turbine dimensions, the tower turbine colors, ladders, distances between the ground and the lowest point of any blade, location on the climbing pegs, and access doors. One drawing may be submitted for each WEC of the same type, a total height. For some reason I have the letter L there. I'll have to check that. Okay. Landscaping plan depicted existing vegetation to describe any areas to be cleared and specimens proposed to be added. Identified species, the size of the specimen at installation, and their location. Lighting plan showing any FAA required lighting and other proposed lighting. The applicant should include a copy of the determination from the FAA to establish the required markings and/or lights for the structure. But if such determination is not available at the time of the application, no building for any lighted facility may be issued until such determination is submitted. A list of property owners with their mailing addresses within 500 feet of the boundaries of the proposed site. The applicant may delay submitting this list until the town board calls for a public hearing on the application. Decommissioning plan. The applicant shall submit a decommissioning plan which shall include the anticipated life of the WECs, the estimated decommissioning costs in current dollars, how said estimate was determined, the method of ensuring the funds will be available for decommissioning and restoration, the methods such as an annual re-estimate by a licensed engineer that decommissioning costs will be kept current, the manner in which the WECs will be decommissioned and the site restored, which shall include the removal of structures and debris to the depth of 3 feet, restoration of the soil, restoration of the vegetation consistent with compatible surrounding vegetation, less any fencing or residential minor improvements requested by the landowner. And it's not residential, it's residual. Sorry about that, residual. Complaint resolution. The application will include a complaint resolution process to address complaints from nearby residents. The process may use an independent mediator and arbitrator and shall include a time limit for acting on a complaint. The applicant shall make every reasonable effort to resolve the complaint. The application shall include relating to the construction installation of the wind energy conversion facility as follows: construction schedule describing the expected commencement and completion dates, a description of the anticipated routes to be used by construction and delivery vehicles, and gross rates and heights of those loaded vehicles. Completed Part 1 of a full environmental assessment form. Number 14, applications for wind energy permits for wind measurement towers subject to this local law may be jointly submitted with the wind energy facility application. For each proposed WEX, include make, model, picture, manufacturer specifications, including noise decibels data, include manufacturer's material safety data sheet, documentation for the type and quantity of all materials used in the operation of all equipment, including but not limited to all lubricants and coolants in it. Give me one?
Yes.
Thank you.
Anybody else?
George.
Thank you.
You want anything in it?
No. Give me some honey. He would have brought it if I knew.
I would have.
Number 16, if the applicant agrees in writing in the application that the proposed WEX may have significant adverse impact on the environment, the town board may issue a positive deck of environmental significance. If a positive deck for environmental significance is determined by the secret lead agency following the information included in the draft environmental impact statement for the wind energy facility, otherwise the following studies shall be submitted in the application: shadow flicker, visual impact, fire protection, noise analysis, and again, I know you were interested in noise, so I'll go through that real quick. A noise analysis by competent acoustical consultant documenting the noise levels associated with the proposed WEX. The study shall document noise levels at property lines and the nearest residence not on site. If the access to the nearest residence is not available, the town board may modify this requirement. The noise analysis shall include low-frequency noises. Property value analysis prepared by a licensed appraiser in accordance with the industry standards regarding potential impact of values of property in neighboring WEX sites.
Hey, let's go back to D for a second.
Yes, sir.
So, I struggle when it says competent. I mean, to me, it seems.
Yeah.
I mean, should we put licensed or some other type of?
I think it's recognized. Isn't it recognized expert in the field? Maybe a good question for Dave. Just so you know, this is in here in the event that we received an application that was less than an Article 12, the 25 megawatt project, because we would have to have this. But because, and those projects are still out there, so this would be applicable to them. This is all being done already in the Article 10 proceeding in that group. So we can look at what they found, and I'll have Dave bring that information with a Monday night for us, so we can go through that then. Make sense?
Yeah.
Okay. F is an assessment of potential electromagnetic interference with microwave, radio, television, personal communication systems, and other wireless communication. The applicant shall, prior to receipt of a building permit, demonstrate that the proposed facility meets the system reliability requirements of the New York State Independent System Operator, or provide proof that it has executed an interconnection agreement with the New York State Independent System Operator and/or applicable transmission owner. A statement signed under penalties of perjury and the information contained in the application is true and accurate. Okay, next, the application review process. The applicant may request a pre-application meeting with the town board with any consultants retained by the town for application review. Meetings with the town board shall be conducted in accordance with the open meetings law. 8 copies of the application shall be submitted to the town clerk. Payment of all application fees shall be made at the time of the application submission. If any waivers are requested, the waiver application fees shall be paid at the time of the all of the receipt paid at the time of the receipt of the application. Town staff, town designated consultants shall within 30 days of receipt or such longer time if agreed to by the applicant determine if the information required in the article is included in the application. Unless the town board waives any application requirement, no application shall be considered until deemed complete. If the application is deemed incomplete, the town board or its designated reviewer shall provide the applicant with a written statement listing the missing information. No refund of application fees shall be made, but no additional fees shall be required upon submittal of the additional information unless the number of WECs proposed is increased.
So where are we in that process?
The problem is a lot of these processes aren't going to be applicable because of the fact we're in Article 10, and a lot of what this law requires has been supplanted by the Article 10 process. So the application process sort of bypasses us, and that's a continuing theme. Okay. The town board shall hold at least one public hearing on the application. Notice shall be given first-class mail to property owners within 500 feet of the boundaries of the proposed WECs to publish in the town's official newspaper no less than 10, no more than 20 days before any hearing. But where any hearing is adjourned by the town board to hear additional comments, no further publication or mailing shall be required. The applicant shall prepare and mail notice of public hearing prepared by the town. These requirements could be applicable to the Article 10 process as well. And shall submit an affidavit of service. Assessment roll of the town shall be used to determine mailing address. Public hearings may be combined with public hearings on environmental impact statements or requested waivers. Notice of project shall be given to the Cattaraugus County Planning Board if required under General Municipal Law 239L or 239M. Secret review applications under WECs are deemed Type 1 projects. Under secret, the town may conduct secret review in conjunction with other agencies, in which case the records of review and communities shall be part of the record of the town's proceedings. Town may require an escrow agreement for the engineer and legal review of all applications and any environmental impact statements before commencing its review. At the completion of the secret review process, if a positive declaration of environmental significance has been issued, the environmental impact statement prepared, the town shall issue a statement of findings, which statement may also serve as the town's decision in the applications. Upon receipt of the recommendation of the county planning board, where applicable, the holding of a public hearing and completion of the secret process, the town board may approve with conditions or deny the application according to the standards of this article. Standards for wind facilities. The following standards shall apply unless specifically waived by the town board as part of a wind energy permit. All power transmission lines from the tower to any building or other structure shall be located underground to the maximum extent possible. No television, radio, or other communication antennas may be affixed or otherwise made part of a WECs except to the town code. Applications may be jointly submitted for WECs in telecommunications facilities. No advertising signs are allowed on any WECs, including fencing, support structures. Nothing in this provision shall prohibit identification information or safety notifications.
So it says, except pursuant to the town code.
Are you on the one above me?
Yeah.
Okay. And that presumes that you have a telecommunication law, which you do not. No.
But if we don't, then, obviously sometimes if you don't have a law, then it's sort of do as do. But
Right.
but in this case, because it says not accept, because we don't, then it means don't and don't.
Yeah.
Okay.
Do you have telecommunication towers in the town of Farmersville?
One.
One? Whereabouts?
He's an expert on that.
Pigeon Hill.
Pigeon Hill.
Is that over by Schwab?
It's above Schwab's.
Above Schwab, though, by the top.
It's 80 foot.
I haven't seen them using these towers for, piggybacking. And I mean, I know might be something you guys would appreciate because I know your
Right.
cell service is pretty
Pretty bad here.
poor out here. But lots of times that on the, I think on the weather communication, you know, the weather sensing, they can put them on those. No advertising signs. Okay, there was 3. We're on to 4. Lighting of a tower. No tower shall be lit except to comply with the FAA requirements for safety and security needs and tower entrance. Minimum security lighting for ground level facilities shall be allowed as approved by the Wind Energy Facilities Development Plan. All applications shall use measures to reduce the visual impact of WEX to the extent possible. WEX shall use tubular towers. All structures in a project shall be finished in a single color or a camouflage scheme. WEX within a wind energy facility shall be constructed using wind turbines whose appearance with respect to one another is similar within and throughout the project. No lettering, company insignia, or advertising. And I think or graphics shall be, and I don't know why that's seems to be, or graphics shall be on any part of the tower, hub, blades, except the tower identifier numbers near the tower base and safety signage. Guy wires shall not be used for wind tower turbines. No WEX shall be installed in any location where its proximity with existing fixed broadcast retransmission or reception antenna for radio, television, or wireless phone or other personal communication systems would materially degrade the signal transmission or reception without mitigation. No WEX shall be installed in any location along a major axis of an existing microwave communication link where its operation is likely to produce electromagnetic interference in its link's operation. If it is determined that a WEX is causing material electromagnetic interference, the operator shall take any necessary corrective action to eliminate this interference, including relocation or removal of the facilities or resolution of the issue with the affected parties. Failure to remedy material electromagnetic interference is grounds for modifying the wind energy permits to eliminate specifics to WEX and WEX causing interference. All solid waste, hazardous material, waste, and construction debris shall be removed from the site and managed in a manner consistent with all appropriate rules and regulations. Land protected by conservation easements shall be avoided when practicable. WEX shall be located in a manner that minimizes significant negative impacts on rare animal species in the vicinity, and particularly bird and pet species. Stormwater runoff and erosion control shall be managed in a manner consistent with the applicable state and federal regulations. The maximum total height of any WEX shall be 600 feet. WEX, or construction of WEX shall be limited to the daylight hours, except for certain activities that require calmer wind conditions than may be expected during the day. The standard for restoration and preservation of farmland in New York State Department of Ag and Markets guidelines for agricultural mitigation for wind power shall be followed. Required safety measures. Each WEX shall be equipped with both a manual and automatic controls to limit the rotational speed of the rotor blade so it does not exceed the design limits of the rotor. B was deleted, or it's eliminated, it's preserved. The appropriate warning signs shall be posted visible in all directions upon approaching the tower. Appropriate warning signs shall be posted visible in all directions upon approaching the tower. Warning of electrical shock or high voltage and containing emergency local contact information. The town board will require additional signs based on safety needs. No climbing pegs or tower ladders shall be located within 12 feet to the ground level at a base of the structure for freestanding single pole or guide towers. The minimum distance between the ground and any part of the rotor blade shall be 20 feet. The WEX shall be designed to prevent unauthorized external access by electrical and mechanical components and shall have access doors that are kept securely locked at all times. Traffic routes. Construction of WEX poses the potential risk being of large-sized construction vehicles and their impact on traffic safety and their physical impact on local roads. Construction and delivery vehicles for WEX and/or associated vehicles shall use traffic routes established as part of the application review process. Factors in establishing such corridors shall include minimizing the traffic impacts from the construction and delivery vehicles, minimizing the WEX-related traffic during times of bus activity, minimizing the wear and tear on local roads, minimizing impacts on local business operations. Wind energy permit conditions may limit WEX-related traffic to specific routes and include a plan for disseminating traffic route information to the public.
As well as minimizing the impacts on local business operations, I know there's been some discussion as far as to the Amish community. I think we should specifically designate that it should minimize impacts on that community as well.
Okay.
At least that's my suggestion.
And I think probably what we'll do, again, we'll take that and we'll get it, I'll work on it, and then I'll get it back to Dave Monday night, just to see how he sees that playing out, okay? The applicant is responsible for remediation of damaged road during and upon the completion of the installation and or maintenance of wind energy facility. A public improvement bond shall be posted prior to the start of construction of wind energy facility in an amount determined by the town board sufficient to compensate the town for any damage to local roads. The applicant shall be required to use designated routes in the most currently dated road use law enacted by the town of Farmersville. Setbacks for wind energy conversion systems.
So is it
I'm sorry?
a road use law or road use agreement?
Yeah, good question. Well, the problem is it says it's enacted, so we'll talk about that Monday night. Statistical sound pressure level generated by WEX shall not exceed L10-50 dBA measured at the nearest residence located off the site. Sites can include more than one piece of property, and requirements shall apply to the combined properties. If the ambient sound pressure level exceeds 50 dBA, the standard shall be ambient dBA plus 5 dBA. Independent certification shall be provided before and after construction demonstrating compliance with this requirement. So there's going to be a before and there's going to be an after. And again, I think we can go through this a little more with Dave on Monday. In the event audible noise due to wind energy facility operation contains a steady, pure tone, such as a whine, a screech, or a hum, the standards for audible noise set forth in section 15A shall be reduced by 5 dBA. A pure tone is defined to exist if 1/3 octave band sound pressure level in the band, including the tone, exceeds the arithmetic average of the sound pressure levels of the two continuous 1/3 octave bands by 5 dBA for center frequencies of 500 Hz and above, by 8 dBA or center frequencies between 160 Hz and 460 Hz, or by 15 dBA for center frequencies less than or equal to 125 Hz. Again, Monday night. In the event the ambient noise level, exclusive of the development in question, exceeds the applicable standards given above, the applicable standards shall be adjusted so as to equal the ambient noise level. The ambient noise level shall be expressed in terms of the highest whole number sound pressure level in dBA, which is exceeded for more than 5 minutes per hour. Ambient noise levels shall be measured at the exterior of potentially affected existing residences. Ambient noise level measurement techniques shall employ all practical means of reducing the effect of wind-generated noise at the microphone. Ambient noise level measurements may be performed when wind velocities at the proposed project site are sufficient to allow the wind turbine operation, provided the wind velocity does not exceed 30 miles per hour at the ambient noise measurement location. Any noise level falling between the 2 whole decibels shall be the lower of the two. Each WEX shall be set back as follows, as measured from the center of the WEX. Number one, 1/3 the tip height, times the tip height or more from the nearest site boundary property line. 1/3 the tip height or more from the right-of-way of any public road. 1,500 feet or more from the nearest off-site residence measured from the exterior of such residence. 1/3 the tip height or more from any structure visited daily by one or more people, i.e. dairy barns or other above-ground utilities, unless waived by the utility company. 2,200 feet or more from the property line of any school, church, hospital, or nursing facility. Wind energy conversion facilities shall be located in a manner consistent with all applicable state and federal wetland laws and regulations. Noise and setback easements. In the event the wind energy facility does not meet the setback requirement or exceeds the noise or other criteria established in this law as existed at the time the wind energy permit is granted, a waiver will be granted from such requirements by the town board upon the following circumstances. 1. Written consent from the affected property owner has been obtained stating they are aware of the wind energy facility and the noise and the setback limitation imposed by this law, and consent and grant 1 to allow the noise levels to exceed the maximum limits otherwise allowed, or 2 allow the setback less than required. And in order to advise all subsequent owners of this burden, and the consent in a form required for an easement has been recorded in the county clerk's office describing the benefit in the burdened properties. Such easements shall be a permanent and they may not be revoked without the consent of the town board, which consent shall be granted upon either the completion of a decommissioning of the benefited WEX in accordance with this article, or acquisition of a burdened parcel by the owner of the benefited parcel or WEX. Waivers granted under this section differ from waivers granted under Article 5 of this local law in that no Article 5 waiver is required if the waiver is given under this section, and Article 5 waiver must be sought rather than a waiver under this section if the adjoining property owner will not grant an easement pursuant to this section. Issuance of wind energy permits. Upon completion of the review process, the town board shall, upon consideration of all standards of this local law and the record of the secret review, issue a written decision with reason for approval, conditions of approval and disapproval fully stated. If approved, the town board will direct the town clerk to issue a wind energy permit upon satisfaction of all conditions for said permit, and permit the building inspector to issue a building permit upon compliance with the Uniform Fire Prevention and Building Code and other pre-construction conditions of this local law. The decision of the town board shall be filed within 5 days in the office of the town clerk and a copy mailed to the applicant by first-class mail. If any approved wind energy facility is not substantially commenced within 2 years of the issuance of the wind energy permit, the wind energy permit shall expire unless renewed by the town board after payment of a renewal fee equal to the original application fee. Abatement. If the WEX remains non-functional and inoperative for a continuous period of 1 year, the applicant agrees that, without any further action by the town board, the applicant shall remove the system at its own expense. Removal of the system shall include at least the entire above-ground structure, including without limitations, transmission equipment, fencing from the property. This provision shall not apply if the applicant demonstrates to the town that it shall be making a good faith efforts to restore the WEX to its operable condition. But nothing in this provision shall limit the town's ability to order remedial action plan after public hearing. Non-function or lack of operation may be proven by reports to the Public Service Commission, NYSERDA, New York Independent System Operator, or lack of income generation. The applicant shall make available, subject to non-disclosure agreement, to the town board all reports to and from the purchaser of the energy from the wind energy facility, if requested, necessary to prove that the wind energy facility is functioning, which reports may be redacted as necessary to protect proprietary information. Must be peas, that prophylactic. Decommissioning bond or fund. The applicant or successor shall continuously maintain a fund or bond payable to the town in the form approved by the town for the removal of non-functional towers and appurtenant facilities in an amount to be determined by the town for the period of the life of the facility. This fund may consist of a letter of credit from the state of New York licensed financial institution. All costs of the financial institution shall be borne by the applicant. All decommissioning bond requirements shall be fully funded before the building permit is issued. The town may enter into an agreement to maintain security for multiple jurisdiction project without further action of the town board. Limitations on approval easements on town property. Nothing in this local law shall be deemed to have given the applicant the right to cut down surrounding trees and vegetation on any property to reduce turbulence, increase wind flow to the wind energy facility. Nothing in this local law shall be deemed to be a guarantee against any future construction or town approvals for future construction that may in any way impact the wind flow to the wind energy facility. It shall be the sole responsibility of the facility operator or owner to acquire any necessary wind flow or turbulence easements or rights to remove vegetation. Pursuant to the powers granted to the town to manage its own property, the town may enter into noise, setback, and wind flow easements, which such items as the town board deems appropriate, as long as said agreements are not otherwise prohibited by state or local law. Permit revocation. Testing fund. A wind energy permit shall contain a requirement that the applicant fund a periodic noise testing by qualified independent third-party acoustical measurement consultant. Maybe that should be the name when we were back. We'll get Dave's permit.
Yeah, once again,
Yep.
well, yeah, I'll be curious what he says.
Or acoustical measurement consultant, which shall be required as often as biannually or more frequently request of the town board in response to complaints by neighbors. The scope of the noise testing shall be to demonstrate compliance with the terms and conditions of the wind energy permit and this local law, and shall include an evaluation of any complaints received by the town. The applicant shall have 60 days after written notice from the town to cure any deficiency. An extension of 60-day period may be considered by the town board, but a total may not exceed 120 days.
So in talking to Dave, and I know that this continues a little bit, but he said that it's not uncommon for this for like the testing fund or even operation, the noise monitoring, like this would be something that's instituted at year 2.
Yeah.
And for the first year, it's a continuous.
Yes.
And then at year 2, it can become more intervaled, like 60 days or
Correct.
whatever.
Because again, as I understand it, a lot of it can be seasonal.
Right.
Whether the leaves are on the trees, the birds are chirping,
Right.
You know,
That's
all
what he
of those
talked
things.
about.
Yeah, and I'm sure, I will send him your questions and your queries tonight, but he'll be ready to address that. Operation. A WEC shall be maintained in an operational condition at all times, subject to reasonable maintenance and repair outages. Operational condition includes meeting all noise requirements and other permit conditions. Should a WEX become inoperable, or should any part of the WEX be damaged, or should the WEX violate a permit condition, the owner or operator shall remedy the situation within 60 days after written notice of the town board. The applicant shall have 60 days after written notice from the town board to cure any deficiency. An extension of 60 days period may be reconsidered by the town board, but the total period may not exceed 120 days. Notwithstanding any other abatement provision under this local law, and consistent with section 19A and 21B, if the WEX is not repaired or made operational or brought into permit compliance after said notice, the town may, after public meeting at which the operator or owner shall be given an opportunity to be heard and present evidence, including a plan to come into compliance, order either the remedial action within a particular time frame order modification of the wind energy permit so as to eliminate the unrepaired WEX and require removal of WEX within 90 days. If the WEX is not removed, the town board shall have the right to use security posted as part of the decommission plan to remove the WEX.
So another thing to talk about Monday and get Dave's opinion on. So when we were going through this, whatever, a year ago or a year and a half ago or whatever, there was a little bit of discussion as far as the timing. There were a few of us that thought the 120 days seemed a little excessive, like a lot of free time for them to sort of. And then there was some of us who were like, well, no, they need that length of time based on ordering parts or supplies or cranes or whatever the logic was at the time. So I guess I'd like to see what Dave says about that. If we can shorten that down. To me, it just keeps it more in compliance on a little bit more stringent basis.
I mean, the problem, probably a lot of the problem is when the 120 days starts to tick. You know, if you,
Wow.
but I mean, they work in the winter, but you know, shipping and everything else. But that's a good question.
Are you trying to say that it was too short or too long? Too long. Too long.
I think I advocated for shorter.
Right.
Others
Because I
advocated
know
for
when we were talking
this.
about that back then,
Right.
we were saying how if we had it as a shorter one, then they could come forward and say, you know, we need more time because the part was back ordered or whatever, and things like that, and then we could okay that. So, okay, I was just wondering what your thoughts were on that.
Wind site assessment. Town board acknowledges that prior to construction of a wind energy facility, a wind site assessment is conducted to determine wind speeds and feasibility of using particular sites. Installation of wind measurement towers, also known as MET towers, shall be permitted on the issuance of wind energy permit in accordance with this article. Application for wind measurement towers. An application for a wind measurement tower shall include the name and address, phone number, and applicant. If the applicant is represented by an agent, the applicant shall include the name and address, telephone number of the agent, as well as the original signature of the applicant authorizing the representation. Name, address, and phone number of the property owner. If the property owner is not the applicant shall include a letter or other written permission signed by the property owner confirming that the property owner is familiar with the proposed application and is authorized to submit the application. Address of each proposed tower location, including tax map, section, block, and lot number. Proposed development plan and map. Decommissioning plan, including a security bond for removal. Standards for MET measurement towers. The standards for wind measurement towers. The distance between a wind measurement tower and a property line shall be at least 1.5 times the total height of the tower. Sites can include more than one piece of property, and the requirements shall apply to combined properties except for the neighboring property are also allowed the consent of those property owners. Wind energy permits for measurement of, I'm sorry?
Bridget, can you hand a couple of the laws that people are looking for?
Standards for wind measurement towers. The distance between a wind measurement tower and a property line shall be at least 1.5 times the total height of the tower. I think I read this already. Okay, wind energy permits for measurement towers may be issued for a period up to 2 years. Permits shall be renewable upon application of the town board in accordance with the procedures of this article. Small wind energy conversion system. The purpose of this article is to provide standards for small wind energy conversion systems designed for home, farm, small commercial use on the same parcel that the primarily used to reduce consumption of utility power at that location. The intent of this article is to encourage the development of small wind energy systems and to protect public health and safety and the community and welfare. Applications, small WEX shall include name, address of the applicant, name, address, and phone number of the property owner for different than the applicant. Address, again, confirming it's the same stuff. Proposed tower location include tax map, section, block, and lot number. Evidence that the proposed tower height does not exceed the height recommended by the manufacturer or distributor of the system. A line drawing electrical components of the system in sufficient detail to allow determination of matter installation conforms with the Uniform Fire Prevention and Building Code. Sufficient information demonstrating the system will be used primarily to reduce consumption of electricity at the location. Written evidence the electric utility provider that serviced the proposed site has been informed of the applicant's intent to install an interconnected customer-owned electricity generator unless the applicant does not plan and so states in the application to connect the system to the electricity grid. A visual analysis of the small WEX is installed, which may include a computerized photographic simulation demonstrating the visual impacts to nearby strategic vantage points. The visual analysis shall indicate the color treatment of the system components. A visual screening incorporated into such project and intended to at least lessen the system's visual prominence. All small wind energy systems shall comply with the following standards. Additionally, such systems shall comply with all requirements established by other sections of this article that are not in conflict with requirements required in this section. A system shall be located on a lot minimum of 1 acre in size. However, this requirement can be met by multiple owners submitting joint application. 1 small wind energy system tower per legal lot be allowed unless there are multiple applicants, which their joint lots shall be treated as 1 lot for purpose of this article. Small wind energy systems will be used primarily to reduce on-site consumption of electricity. Tower heights may be allowed as follows: 65 feet or less on parcels between 1 and 2 acres, 120 feet on parcels of 2 acres or more. The allowed height shall be reduced if necessary to comply with the applicable FAA requirements, including subpart B, commencing with section 77.11 of part 77 of Title 14 of the Code of Federal Regulations regarding installation close to airports. The maximum turbine output is limited to 100 kilowatts. The system's tower and blades shall be painted in a non-reflective, unintrusive color that blends with the system and the components in the surrounding landscape to the greatest extent possible, and incorporate non-reflective surfaces to minimize any visual disruption. The system shall be designed and located in such a manner as to minimize adverse visual impacts from public viewing areas. Exterior lighting on any structure associated with the system shall not be allowed except which is specifically required by the FAA. All on-site electrical wires associated with the system shall be installed underground for tie-ins shall be installed except for tie-ins to public utility company and public utility company transmission poles, towers, and lines. This standard may be modified by the decision maker if the project's terrain is determined to be unsuitable due to reasons of excessive grading, biological impacts, or similar factors. The system shall be operated such that no disruptive electromagnetic interference is to be caused. If it has been demonstrated that the system is causing harmful interference, the system operator shall promptly mitigate the harmful interference or cease operation. Signs shall be posted, visible from all directions, on the tower at a height of 5 feet, warning of electrical shock, high voltage, harm from revolving machinery, and giving local contact numbers in case of emergency. No brand names, logos, or advertising shall be placed or painted on the tower, rotor, or generator, tail vane, where it would be visible from the ground, except for the system or tower manufacturer's logo may be displayed on a system generator housing in an unobtrusive manner. Towers shall be constructed to provide one of the following means of access, control, or other appropriate method of access. Tower climbing apparatus no closer than 12 feet to the ground, an anti-locked, anti-climb device installed on the tower, a locked protective fence at least 6 feet in height with enclosures closes the tower. Anchor points. For
So,
any,
Just, it strikes me that on this one, so for the large tower, it says the climbing apparatus is located no closer than 12 feet from the ground, but it doesn't say anything about a locked anti-climb device installed on the tower. I mean, I think if you do it for the small tower, you do the same sort of prevention for the large tower.
my understanding of the locked anti-climb device is a ladder, and it's up 12 feet.
Right.
I think the large ones,
Oh, you're saying that there's no,
every-
so So this has a ladder that goes down, sort of like
This could be a lattice type tower.
a fire escape type thing?
Yep.
Okay,
You
well,
with me?
we should, yeah,
Most of the major WECs,
because the
they're-
ones are tubular, these could be
yeah,
sort of like the tower there on the 80-foot Wi-Fi tower would be similar, where you have the anti-clanging, okay.
anchor points for any wires for system towers shall be located within the property that the system is located on and not act on or across or any above ground electric transmission or distribution lines. The point of attachment for guide wires shall be enclosed by a fence 6 feet high or sheathed in bright orange. Again, this is a snowmobiler. Construction of on-site, what is it? It's a snowmobile. The bright orange yellow coverings, and it's 8 feet high or 6 feet fencing is so you don't run your snowmobile underneath those guy wires.
Oh,
That's what
okay.
that's all about. Construction of on-site access roadways shall be minimized. Temporary access roads utilized for installation shall be regraded and revegetated pre-existing natural condition after completion of the installation. To prevent harmful wind turbulence from existing structures, the minimum height of the lowest part of any horizontal access wind turbine blade shall be at least 30 feet above the highest structure or tree within 250 feet radius. Modifications of this standard may be made when the applicant demonstrates the lower height will not jeopardize the safety of the wind turbine structure. All wind energy system tower structures shall be designed and constructed to be in compliance with certain provisions of Uniform Fire Prevention and Building Code.
Can I go back?
Yep.
That's a lot,
The one above.
yeah.
Again,
Harmful
think about what we're
turbines.
doing. We're dealing with little ones, not
Right.
the big ones.
No, I
Yeah,
understand.
go ahead.
I just
The
prevent
lowest
harmful
part of the
wind
horizontal axis wind turbine blade shall be at least 30 feet above the highest structure or tree within 250 feet radius. Again, what you're doing is eliminating the radius eliminating the obstructions from the wind.
I'll have to read that over. That's fine.
That's fine.
I just can't visualize it.
I got it. It's like the other night with the building. Had to draw a picture.
Yeah.
Had to draw a picture. Again, we can come back to that. All small wind energy towers. Again, these are all the stuff that was last July when I walked in the first time. This isn't anything that's changed.
Right, no, I know.
I know. Just we've looked at it and we really haven't concentrated on these small WECs very much.
Right.
All small wind energy systems shall be equipped with a manual and automatic overspeed controls. Standards, all small WEC systems comply with the following standards. Setback requirements, small WEC shall not be located any closer to property line 1/2 times the total height. Noise except during short-term events, including utility outages, severe windstorm. A WEC shall be designed and installed and operated to a noise generated not to exceed 50 decibels as measured at the closest neighboring inhabited dwelling. Abandonment of use, a small WECs not used for 12 consecutive months shall be deemed abandoned. WEC shall be removed from the property at the expense of the property owner. Failure to abide faithfully and comply with this section with any and all conditions may be attached to granting a building permit and shall constitute grounds for revocation of the permit. All WECs shall be maintained in good condition in accordance with all requirements of this section. Waivers. Town board may, after a public hearing, which may be combined with other public hearings on wind energy facilities, so long as the waiver request is detailed and in the public notice, grant a waiver from the strict application of provisions of this local law. If in the opinion of the town board, the grant of said waiver is in the best interest of the town, the town board may consider reasonable factors in evaluating the request, which may include, when applicable, the impact of the waiver on neighborhood, including the potential detriment to nearby properties, the benefit to the applicant, feasible alternatives, and scope of the request. Waivers so granted run with the land, the wind energy facilities granted a waiver are deemed to be in compliance with the relevant positions of this local law. The town board may attach conditions it deems necessary and appropriate for a waiver approvals if it deems necessary to minimize the impact of the waiver. Fees. Non-refundable application fees shall be WEC's wind energy fee is $300 per megawatt of rated maximum capacity. Wind measurement towers shall be $200 per tower. Small WEX wind energy permit, $150 per WEX. Wind measurement tower wind energy permit renewals, $50 per wind measurement tower. Waiver application, $100 per tower. Building permits. Building permits are required for each wind energy facility. The town believes that the review of a building and electric permits for wind energy facilities other than small WEX requires specific expertise for those facilities. According, a permit fee for such facilities shall be $300 per permit request for administrative costs, plus the amount charged to the town by outside consultant hired by the town to review the plans and inspect the work. In the alternative, the town and the applicant may enter into an agreement for inspection and/or certification procedure for these unique facilities. In such case, the town or the applicant will agree to a fee arrangement and an escrow agreement to pay for costs of review of the plans, certifications, or conduct inspections as agreed by the parties. Nothing in this local law shall be read to limiting the ability of the town to enter into host community agreements with the applicant can compensate the town for expenses or impacts. The town shall require the applicant to enter into an escrow agreement to pay engineering and legal costs of any application review, including the review required by seeker. Tax exemption. The town hereby exercises its right to opt out of the tax exemption provisions of real property tax law 487 pursuant to the authority granted by paragraph 8 of that law. Enforcement penalties and remedies for violations. Town shall appoint such town staff or outside consultants as it sees fit to enforce this local law. Any person owning, controlling, managing building or structure or land who shall undertake a wind energy conversion system or wind monitoring tower in violation of this article or in non-compliance with the terms and conditions of this permit issued pursuant to the terms or any order of enforcement, and any person who shall assist in so doing shall be guilty of the offense and subject to a fine of not more than $350 and imprisonment for not more than 15 days, subject to both such fine and imprisonment for the first offense, for such second offense both for a period of 5 years, a fine of not less than $350 nor more than 7, and imprisonment not to exceed 6 months or both. And for a third offense which occurred within 5 years, a fine of not less than $700 nor more than 1,000, or imprisonment not to exceed 6 months or both. Every such person shall be deemed guilty of a separate offense for each week such violation shall continue. The town may institute a civil proceeding to collect civil penalties in the amounts set forth herein for each violation. Each week said violation continues and shall be deemed a separate violation. In the case of any violation or threatened violation of any of the provisions of this local law, including the terms and conditions imposed by the permit issued pursuant to this local, in addition to other remedies and penalties provided herein, the town may institute an appropriate action proceeding to prevent such unlawful erection, structural alteration, reconstruction, moving and/or use or restrain or correct such abatement, such violation, and prevent illegal. Should any provision of this local law be declared by the courts to be unconstitutional or invalid, such decision shall not affect the validity of this local law or as a whole or any part thereof. Repealer all resolutions, ordinance, and local laws or parts thereof in conflict herewith, which in any manner or in the absence of this local law would address and apply the approval, construction, and operation of wind energy facilities are superseded by this local, specifically local law number 1 of 2007, 1 of 2008, 1 of 2009, would take effect upon filing.
Just, you done now? You had said the 60 days, so it should be less than 60?
I don't know. I mean, something to talk about. I think I wasn't so much concerned about the 60, I was concerned about the 120.
But that's only if we approve it, the way I read it.
Yeah, 60, and then they can apply for
An
a year.
extension, we'd have to approve the 60 days.
I understand.
Yeah.
No, it's fine. I mean, it just, yeah.
Why doesn't the law address shadow flicker? Did anyone at this table tell
Again,
the residents
we
here?
explained to you, we're not taking public comment tonight.
It's
So
not
you,
it's a comment
no,
to you. Can you tell
I'm
these
not
people
taking public
how many Farmersville residents are getting hundreds of days of shadow
Ginger,
flicker?
you can either sit there or you can leave. It's your choice.
So it's your way forward.
You can either listen to us work or you can leave.
We are the town.
Look, this is our
It is
meeting.
right.
Right,
It is
and
public.
you don't have,
We're
you do
answering
not
questions. We are
have
the public.
the right
We are the
out.
public.
We're addressing
They need to
development.
leave. You're done. We're done. Thanks.
Why?
Because of the fact,
Because
it's a meeting.
David's afraid to hear from the public? Is that the
I've
problem?
listened to you.
There'll be time and place for that, but that's not tonight.
When is the time and place? Tell me when the time and place is.
We already have public hearing.
When is it?
Rob, we're done.
Why do we have a surprise meeting? We just
After you
had
say
the
you're
board
not
meeting.
passing the wind law, now you have this meeting, and now you want to kick people out when you don't even
I'm not
want to answer
listening.
to people?
Again,
People?
you gotta stop this.
listen to something, not even the town.
So we're meeting on Monday night, right? Date for coming
None of you read this application, not one of you.
Why don't we just adjourn?
here.
Sure don't.
Well, do you need anything else?
No, I'm good. I may call you, but
I
I'm
want
good.
you all
What's
to
that?
look at
Oh, I may
reception
call you
number
on-
3534.
Okay, I'll be at home.
Yeah.
Thoroughly understand.
You done?
what you're just
Yeah, I'm
listening to
done.
this man read.
I propose that we end the meeting.
Okay.
Wanna make a motion?
By George,
I'll second it.
and by Richard. All in favor?
Aye.
Monday night, 7 o'clock, okay?
Thank you.
Was that Monday night at 7? I couldn't hear out here.
Yes, Monday night at
Monday
7.
night at 7, okay.
Thanks, George.
Another meeting where they won't care what anyone says.
Any of the supporters stick around for this or no? Every one of them left. They knew they did.
I totally disagree with allowing a lawyer to run your meeting. I think that's ridiculous. Obviously, our town supervisor can't handle his own meeting. He's allowing the attorney to determine who stays, who goes. They refuse to answer any questions pertaining to the law that they're working on. I don't see where that's getting the town anywhere. They've built things into that law and gone over it again that the county of Cattaraugus has already turned down, denied, kicked back. They've said that doesn't fit within the image of the county, and yet here it is, re-proposed with less protections.
Well, I'm sure they would have tried to snuck in a vote if we weren't here. At least we kept them honest so far, but it's certainly appalling for Invenergy to be here for a local wind law, and then for them to bring operations engineers here with a big display truck. I'm dumbfounded on the arrogance and how the town residents voted in the primary election for greater setbacks and safety, and our town board continues to ignore us. It's very frustrating and aggravating. It's so disappointing. It's so frustrating. You know, when I talk to people from other towns and they say how they conduct business and they value and they ask for input from the town residents, and our town board does the opposite. It's like we're going to do what we want, and too bad. On June 17th at the town board meeting, they stated that there was going to be no wind law this year, and the primary election came, and they still don't care. We overwhelmingly beat them. The current town supervisor is not even on the ticket for the election. The residents have spoken. And that doesn't even represent out-of-town landowners and the Amish, one of the biggest growing communities in America and in our town. They pay taxes and they restore beautiful old farms. And it seems like none of these people have a vote, and the town board doesn't want to hear anything they have to say, except for a few leaseholders.
Let's see, they discussed low-frequency noise, but didn't discuss infrasound, which is between 0 and 20 hertz, which is the most harmful of the frequencies, which cannot be tested for before the wind turbines are up, because bodies have different resonant frequencies and buildings have different resonant frequencies. So there's no way to test for that. The only thing to assure against it, and the multiple cardiovascular difficulties that come up with that, is to distance them from the people. On top of that, audio noise is recommended to be between 35 and 50 hertz for the World Health Organization for sleeping. If they're going to go up to 90 in the middle of the night, just regular old sleep deprivation destroys health, gives you high blood pressure, diabetes, and a host of other things. The infrasound is even worse. So that's both right there. So, and also the fact that they're supposed to be green is a crock, because rare earth minerals are mined that cause more radioactive waste than all the nuke plants in a year with their waste. So the fact that they're saying it's green is BS. Also, I'm just so frustrated, I'm sorry. The disposing of the turbine blades, which have to be replaced constantly, they can't burn them, they bury them. There are thousands of tons of that underground. The thousands of acres of CO2 breathing trees that they're chopping down are not green. The animals they're killing, the earthworms that are moving, the bats that are destroying everything under the sun. But most importantly, our health, our lack of sleep, our lack of our nervous system. I mean, everything is affected because it makes your cells basically vibrate until they become stiffened, which gives you high blood pressure and leads to, well, tonight is vertigo, dizziness, nausea, you name it. So they're not addressing our health, safety, and welfare. They haven't given a crap about it since day one. They haven't shown any interest in any of it anytime it's ever been brought up. Not one question has been asked about how we feel about it or what the actual effects of it are. And this is a farce.
Well, they're going to come back here on Monday and again go through more predetermined machinations to pretend that they're taking a hard look at this law. They're going to completely ignore everything that they've ignored for the past year of the residents' concerns, and they're going to pass the wind law that Invenergy has asked them to pass. That's what's going to happen.
Not listening to the people.
Apparently, because you've lost the primaries, you just don't really care. You don't care that people are going to come in. You don't care